Good afternoon, everybody, or good evening, depending on where you are. My name is Awasar. I'm Assistant Director for Academic Affairs at the African Studies Center at MSU. This is Ion Africa, our weekly seminary series. I'm very delighted today to welcome Dr. Anika Wilson. Dr. Wilson is the current chair of the Department of African and African Diaspora Studies at the University of Wisconsin, Milwaukee. She earned her doctorate in folklore and folk life studies at the University of Pennsylvania and specializes in the gender narrative and spirituality in Northern Africa. Her book, Folklore, Gender and AIDS in Malawi, No Secret Under the Sun, published in 2013, was awarded the Eli Konga Maranda Award for Feminist Scholarship in Folklore in 2014. She teaches courses in African cultures and societies, spirituality, and gender relations. One of her current projects involved the analysis of legends and beliefs related to sacred sites in Central and Southern Africa as they are linked to ideas about spirituality, religion, and ecology. Her other main project examines the nature of argumentations and the representation of gender expectation in divorce court transcript from Malawi. Her talk today is titled Localization of Human Rights Discourse, Defining Gender-Based Violence in Malawian Court. Welcome, Dr. Wilson. We're very happy to have you today.
Thank you guys so much for having me. I really appreciate this, and I'm looking forward to any questions and discussion that we have in the end. I'm just pleased and delighted to be with you guys today. I don't remember the exact title apparently that I gave, but the title that I have on my PowerPoint slide is The Localization of Human Rights Discourse, Gender-Based Violence Arguments in Malawian Courts. All right, I'm trying to see if I can advance my slide. All right. Yeah, we don't need to see this. So this research comes out of, grew out of my earlier project, which was the book that Awa was mentioning. And that book, published in 2013, focused essentially on looking at ways that women were navigating the HIV/AIDS epidemic, but doing so through the apparatuses that were already in their communities. So what were the avenues that, I asked the questions like, what are the avenues that women have for dealing with their sense of risk to HIV/AIDS, and what are the institutions that women were using? So again, it's not just about women. Obviously, these are the same institutions that men are using to navigate gender identities, but that particular project was based on or centered on women's experiences and women's perceptions of what they're able to do. What can you do about a situation of an imbalance of power through the institutions that you already have? So whether it was through your marriage go-betweens and Nkoswes, or whether it was through your aunts, right? And I was doing research in a mostly an area where patrilineal or sort of patrilineal type processes were more common than matrilineal processes. And so women were trying to deal with the situation of, okay, so I have some institutions at my disposal, but I'm entering into these institutions, whether it's going to a village head or going to the relatives surrounding you, the in-laws surrounding you. I'm doing this in an environment that is outside of my home environment. And what does that mean for how I'm going to navigate the situation of, you know, getting some control over things within my marriage, right? So that project sort of keyed me into ways in which people are doing things on I guess I would say sort of an informal basis, like the expectations of what women had to do in order to navigate risk. So I keep saying that, but I guess I'm talking about the risk of multiple partnerships or concurrent partnerships, and the question of how do women navigate these situations where they are not, how do I best put this? The issue was, the bigger question that I had was, if you are not having full control of everything in your life, right? The way that a sort of public health perspective might suggest that you just make decisions about abstaining, being faithful, and using condoms to avoid AIDS. My research took place in a situation of asking, well, let's say that you don't have complete control because you make these decisions in relationships. So how do you navigate these relationships? What are the tools at your disposal, right? That you don't have complete control. So you do have to talk to the aunts, or you do have to talk to the marriage go-between, or you do have to talk to the village head. So there's all of these people who have a say in what you're doing, that you don't have this complete bodily autonomy that we think about as individualized actors, right? So that sort of that project led me from thinking about what happens in these informal spaces to what happens to more formal spaces. So this is where we get to the project that I'm discussing today. If women are, and men of course, are trying to navigate or negotiate marriages through these informal structures, what does it look like when it moves to more formal or more state shaped apparatuses of marriage negotiations? So I look to the courts, because sometimes when I spoke to people, that would be, like last resort, we're going to try to take this issue that we have about infidelity or polygamy or someone not fulfilling what they were supposed to do in the marriage or not providing. We're going to take this to another level, or if there was domestic violence, right, or gender-based violence. And so this project comes out of that issue, right, of what happens in the more formal settings. Do women who feel that they are in a position of less power in an informal setting, do they find themselves gaining more power when they go to a formal setting, right? And the reason this is very significant to me, is because you see the flourishing of organizations around gender, or as it's kind of rendered in Malawi, gender, right? And you also see a proliferation of legislation around gender and gender rights, starting in around the 1990s, where you have this international redefinition of women's rights as human rights. And so this is something that organizations like the UN and CEDAW, you have these conventions meeting and getting together and saying, we have to attend to issues surrounding women's rights, and we have to define these as human rights that need protection of these international organizations. And so you also see proliferation on the localized level of a number of laws and statutes for not just Malawi, but across the world, of people and organizations saying that we're going to use this human rights structure, this human rights framework, in order to deal with some of the inequalities or issues that women face. Because now we have this globalized discourse and globalized structure around supporting women's rights as human rights. So my research comes out of looking at court transcripts. Most of these transcripts were in English, with some aspects of the file written in various local languages. So I gathered a number of court files, about 180. I actually have more, but they're still being typed up at this time. But right now, the ones that I'm drawing from for this have a limited time frame from 1998 to 2008, where I'm looking at, okay, so how do some of these discourses around women's rights as human rights, do we find that they are entering into people's argumentation, entering into the way that people discuss what their rights are, what their responsibilities are, what their expectations are as women or men or spouses or various parties? Because it's not always the husbands and wives that are represented in these court cases. So there's certain types of limitations to this set of data, which is that all of these court transcripts surrounding marriage and divorce, they're all written in English. So we don't have a sense of the way that vernacular terms were used. They're automatically in the transcription by the court official, they're translated into English. There's also maybe some biases of either the person who was doing the transcription or who was helping to select the cases that were provided by the court to me and the people I worked with, because we asked for cases about marriage and divorce. So there may have been things that dealt with these issues that they didn't think sort of fit what we were talking about, that they selected for us. So that might mean there's certain biases that are built into this. And the time frame at this point is limited. I'd like to, in the future, get access to cases that started earlier and also continue collecting cases that are have taken place since 2008. So those are some limitations. At the same time, you can see that, you know, still have a pretty wide time frame there for these cases that I'm going to discuss. And so there's many different things that we could talk about with relation to gender and gender rights. But what I want to talk about today is mostly the way that laws and the language around domestic violence or gender-based violence have been grasped onto by the courts and litigants and magistrates. All right, a little bit of background. So in the literature relating to issues of gender, this term, when you render it into the local usage of it, it often sort of signifies or is made to signify the idea of men being disempowered. And some see this as a kind of shallow adoption of the concept of gender and gender rights or women's rights. And it's usually, the other part of this is usually when they say gender, it's not talking about gender as a term that envelops everyone. It's more specifically talking about a term that is about women's rights. It's about, it's not about like discussing the way that the roles, gender roles often cause problems for both men and women, or the way that they overly determine what the roles are supposed to be, or that they dichotomize manhood and womanhood in problematic ways. But the way that you see people using this term in you know, everyday conversation, as well as what you see in the news media, what you see government officials talk about, gender is often talked about as either empowering women or disempowering men. And so some have talked about that as a kind of a shallow adoption of the concept. Another way that we see the notions of gender deployed is and arguments around custom and culture. So there will be arguments saying that there's customs or cultural practices, as the usual terminology used, that are harmful and that they need to be amended in order to give women some rights or grant greater equality or equity for women. Another way we've seen the literature discuss gender is and this is a lot more instrumental. And when we look at the local organizations in Malawi and the way that they are analyzing women's path to justice. So we see in the literature that is created locally, people are just talking about how can we make it so that women can navigate these complex systems, right? Because we have the informal, we have the formal, we have the connection between the non-state and the sort of state. I'm saying that the sort of like non-state as being like the family dealings around marriage disputes versus the state, and how those actually intersect and one sort of relies on another. An example of this is if a person brings a case to court over marriage and divorce, or disputing some claim related to, like, I want, access to this property, or I want custody of children or something like that, often you'll find that the judge may say, no, well, did you get a letter from the headman? Did you get a letter from the traditional authority? Did you do these other things first before you came here? So this is sometimes a response where there's an expectation that you have to do that informal thing first before you can access the formal system. And another way we see gender talked about with relation to courts has been historically in the way that courts have, men have been seen to consolidate their power through the freezing of customary law, making what was fluid systems of marital argumentation and argumentation for rights and access to things to something that is like a set of rules, and a set of rules that were during the colonial period made to enter into the statutory, the court setting, the governmental court setting in ways that consolidate power of older men and the patriarchal structures. So those are some of the ways, if you look at the literature, that we see gender being discussed. But my question is whether or not, so one of the main questions I have is whether or not this new sort of approach to gender, which is saying that we can look at gender rights through a human rights lens, and this can create new opportunities. How does this happen? How does this get translated to local levels? How do people grab a hold of that discourse for their own means? Can they reverse things like, can women or advocates for women's rights reverse issues around the consolidation of gerontocratic power, patriarchal power that accumulates both in the informal and the formal settings? Is there a way that this language of women's rights can actually do that? And so as a starting point, I took some of the concept of Sally Ingle Mary when she wrote about, and I don't think you guys are probably familiar with this text, Human Rights and Gender Violence. I should be putting up my own book actually, but that's okay. Shouldn't be advocating this for other people's books. But she essentially talks about ways in which international laws get translated. So I kind of took that framework of asking, how do people take these discourses that are created to be universalist, but are not really universalist, and how are local constituents and local actors able to translate these international, supposedly universalist discourses into a set of practices that make sense within the local context. And some talk about this as a vernacularization of international law, or the localization of international laws, the terminology I'm using right now. But the idea is that human rights language can create like another tool or another space for people to have some autonomy or to change systems that they see as bothersome. And sometimes not so much even as changing the system, sometimes it's more making an advantage or making a space in places where they don't usually have space. The critique of this is that sometimes these languages or sometimes these apparatuses actually may displace other visions of social justice and responsibility-based justice. So rather than rights-based justice, there are communities where the language is more about responsibility. So I'll be bringing that up later again. All right. So I talked about how in the 1990s, women's rights become human rights in international law and advocacy. And again, that local communities began to use human rights tools in their agenda. But one of the issues that people have found throughout the world who try to use women's rights as human rights is that sometimes the language of culture has been essentialized. And what do I mean by that? I mean that culture, even though you can talk about culture as a fluid thing that's always changing, that is historically contingent, the practices and beliefs that people have came about in particular conditions, and the conditions always changing, so culture is always evolving. But in a post-colonial, in the post-colonies, you might say, sometimes the language of culture becomes very contentious and becomes something that's essentialized rather than fluid. So an example of this is where we see individuals talk about, well, a good example of this I want to use is from another text that was written about Malawi, which is politicizing sex in contemporary Africa. It's about homophobia in Malawi. And the author, Ashley Currier, writes how in post-colonial Malawi, that if you talk about homosexuality in a negative way and you're a politician, you can use this as a kind of issue to claim greater authenticity. And you can say that homosexuality is a Western import that Western countries try to impose on African cultures, and that we have to, as autonomous states, now reject anything from the West because it is an imposition, right? So then that's where the culture, there's an idea of like tradition or culture that is being used as a kind of like a wedge issue. And also if anybody advocates for the rights of homosexual individuals, that is sometimes paired with women's rights and other things like that. And so suddenly you can undercut all kinds of gender rights efforts. So in this case, you can say that culture has been essentialized as something that's unchanging or is naturalized. This is what we feel here. This is what we do here. These other things are of the West and they're unnatural. So that's one example, right, of culture being essentialized and needed to be defended from the onslaught of Western influence and things like that. So this is one, so that way of thinking about using culture by politicians or other types of public figures, we also see this a lot in religious figures. That way of discussing culture is sometimes used to push against these claims of women's rights as human rights. I don't know if that's making any sense, but we can talk about that some more. I'm trying to get a lot of things into this talk. All right. I think I already talked about that, so I'll just move on. All right. And so where this issue of culture becomes especially useful to think about is in the ways that you see the Constitution, not only the Constitution in Malawi, not only enshrines the right for women to have, equal rights to men, but it also enshrines the quote unquote right to culture. Every person shall have the right to use the language and participate in the cultural life of his or her choosing. And so this also is taken into consideration when we have magistrate courts looking at cases of marriage and divorce and saying that we have to judge each case by the culture from which each person comes. And so if the people are coming from a culture, the people that come before the court are coming from a community that does things in particular ways that favor men over women, then the courts are able to say, well, we have to do this because everybody has a right to culture. So the question is, by using this new language around rights, are people able to subvert, the ways in which customary law has sometimes been used in order to continue to support the status quo about patriarchy? Right. So one thing we need to do then is to think about what are the things that have entered into the practice of law, or the concepts that have entered into the practice of law that may shift to some extent the ways in which rights and responsibilities are understood, right? Or at least not only understood. Yeah, we'll just leave it there. How do these new ideas kind of shift the meanings and the terminologies that were already in place? When you add something into a system, how is it going to shift what's already in that system, and what are the results of those shifts? And so what we have entering into the system is an idea of the need to protect especially women, but also children and other vulnerable groups, as the terminology is used, from violence. The word is glossed as Nkanza, relating to in the local vernacular. So we have a plethora of ideas that are subsumed under the concept or the terminology of Nkanza, or violence, which sometimes people, in the English back translations will say violence, harshness, cruelty. Under the specific set of laws that were created by Malawi, especially domestic violence law of 2000, the law of 2006, violence can be anything from physical violence, sexual violence, emotional violence, psychological violence, social, economic, and financial abuse. All of these things are subsumed under the idea of Nkanza, or violence. And so what I want to look at now is I want to turn from sort of this background information to think about, to apply these ideas to some of the rulings and some of the transcript we have. So what I've done here is taken some examples, some exemplary cases to analyze with respect to how do we see the concept of violence being used, and how might this constitute a type of a shift. So, and I'm specifically interested in both how the magistrates rule and how litigants are using this terminology. So the term violence itself, we only see in the transcripts of about 8 of these cases, but we see cruelty come up, a lot, about 24 of the cases. Beat came up, so people being beaten came up in about 55 cases, and the terminology of abuse. And so there's a lot of different, so I'm looking at all of these things as a piece, as all of these are ways that people indicate that there was some kind of abuse. And, you know, if it says beat, then that's obviously a specifically, excuse me, that's a specifically physical abuse situation. But we also, you'll see in some of the cases I show that when people talk about cruelty, which is also glossed under Nkanza, that cruelty doesn't always relate to physical abuse. So Nkanza is being made to do a certain amount of work. Let's see if I can make me even smaller so I can see what I'm writing. All right. So I'm just going to run through a series of excerpts from cases that discuss cruelty and how cruelty is used, or cruelty and violence is used. So I've broken them down to different categories where cruelty is used. One in talking about abandonment or the chasing of someone away from the home. Whoops, what's happening? Another is in sexual or physical abuse. Another one is in the withholding of sex. Another one is in verbal or psychological abuse. And then I want to talk a little bit about responsibility-based arguments. So abandonment and chasing. So in this excerpt I provided here, the applicant raised the ground of ill treatment or cruelty. Backtrack, a large percent of the cases that are brought to the court around marriage, or brought to the government court around marriage and divorce, are brought by women. So over 80%, I would say. So that's just some background. So we can certainly say that women, especially in this region of the country where it's patrilineal type processes are in play the most, we see this. I'd be interested in comparing to other parts of the country where matrilineal practices are more, or are of a greater predominance. Because some might suspect, well, maybe women don't need to use the court as much as men, but clearly I kind of get the feeling that it's similar patterns. But anyway, at any rate, in this region of northern Malawi, this case discussed, this magistrate who is giving the ruling in this case is kind of summarizing all that was said by the litigants. And the applicant raised the ground of ill treatment or cruelty. She said her husband was not caring for her. He could leave her in her house for a period of 1 year. He was stopping to buy her necessities. He did not care for her last pregnancy and born child. He attempted to burn her in the house and her clothes. Her parents knew all these things. All the issues raised by the applicants are prima facie cruelty at best. There can be no doubt that the respondent was ill-treating his wife. He was very cruel to her. The lady knew no peace in her matrimonial home. She stayed in a troubled life. She is forfeited to seek divorce. I find the respondent liable for cruelty. I find no reason to delay the dissolution of the marriage. Right, so cruelty here, all of these things are seen as violence. We have the physical violence of trying to burn the house and the clothes, but those weren't all of the things that were being considered violence, right? The violence of not providing, and we can question whether that it relates to the role of the husband, and we'll see that later on in other excerpts that this is certainly the case, that right, it's cruelty for a husband not to fulfill the role of taking care of the wife, as is related to the expectations, right, of that gender position. She had a troubled life, right? All of these things are adding up to an idea of cruelty, of Nkanza, of violence, right? And then there's more straightforward physical and sexual abuse. And this is another excerpt from a magistrate. As I said earlier on, this is a divorce case. The plaintiff brought the case on the ground of cruelty. She also said her husband has insulting her, right? And her people heavily of late. The defendant unequivocally admitted having insulted the plaintiff. So this is also, this excerpt discusses both physical and verbal abuse. For the defendant to use such words against his wife of 26 years and her parents-in-law was an abomination. A gentleman with 5 children and grandchildren is not expected to use such abusive words. I find the defendant's behavior very abnormal. No sane person can tolerate to stay with a man who does not care to use any words that come in his mouth. His insults were in no doubt causing psychological torture. Such conduct amounts to cruelty. On the alleged 2 assaults, the defendant did not say anything, though during his plea, he had been fighting with his wife. I find that it's not true that his wife ever fought him. It is true that he was beating his wife. From what his wife said, she had been assaulted heavily on both occasions, and on the first occasion, even spat on his wife's vagina. Like what I said on the abusive words, this is my first time to hear a reasonable person spat on the vagina of his wife. The conduct of the defendant to his wife was very unacceptable. It was cruelty at best. The plaintiff proved her claim against him on the ground of cruelty. All right. But in the same case where the magistrate was discussing the psychological torture, the abusive words of the husband against the wife, he also ruled that the wife had tortured the husband by withholding sex. On the issue of her refusal to have sex with her husband, I find this conduct to be cruel to him. Refusing one's spouse sex causes psychological torture. She was the only wife to the defendant. As a wife, she was duty bound to provide sexual services to him, except when she was sick or barren by cultural beliefs. Right. So here we also see the idea of the magistrate heavily drawing on the idea of culture, and also, but still using the terminology of inkansa, of abuse, of cruelty, to discuss a woman withholding sex from her husband. All right. Later on in the quote says, she was even asked why she was refusing him sex. She gave her reasons. Solutions are offered to her and she went for complete sterilization. It is therefore strange to learn that after sterilization, she continued to deny him his marital rights, right? Here's the language of rights. His marital rights to have sex with her whenever he wanted. It was her refusal for sex, excuse me, that infuriated him to keep on accusing her of being a whore and insulting her, mentioning her private parts all the time, right? So her, the offense of the wife in this case was that she was psychologically torturing her husband by withholding sex, which is argued to be her duty to provide, and his right to access. Right. We already had a case I talked about verbal or psychological abuse, but here's another example. But I think the other case I showed pretty much does a good job of covering the way that verbal or psychological abuse, insulting, saying things that are kind of taboo to say, speaking to in-laws in a particular way that is indiscreet and brings up things that you don't bring up to your in-laws. All of these things are seen as part of psychological verbal abuse. Name calling, all of that. So you might say that in these cases, that the language of Nkanza wraps up a lot of different things. Definitely, you can see that that there are people who are using the language of cruelty or making claims on the basis of cruelty that are very much falling into this idea of this rights-based language. Like you do not have right to talk to your wife like that. You do not have a right to talk to your parents like that. That is cruel, right? You have done the wrong thing. At the same time, you see that there are all this use of the language of violence or inkanza is also relating to things that would already have been discussed as part of a customary law type argument, right? What are the expectations, right, of a husband to a wife? What are the expectations of a wife to a husband, right? And taking those expectations and wrapping them in the language of rights, but continuing to use the language of duty and responsibility as well, right? So this is where you see that these languages of inkanza, of cruelty that come down from international law are very much being used in a way that also intersects with ideas about customary law and cultural rights. And so I want to give another example of this that relates less to the idea of rights or entitlement, but or rights in the way that we talk about in international human rights law, as some kind of inalienable right that one is born with, for example, to the language of responsibility and also earned entitlement. And so the other case I want to talk about is one where there was a dispute between, I'm going to skip ahead, dispute between a husband and a wife, and the wife wanted to divorce. And in this case, the plaintiff, these are pseudonyms, Diana, was accusing her husband of leaving the family, not financially supporting the family, and not building a house. She brought witnesses who also stated that she had built her house alone. And when the judge heard this case, he said that the husband was a cruel man, and that he did not live up to his responsibilities as a husband. He was the one who was supposed to build the house. He also called him a useless man. He didn't support his wife or children financially. And I saw this was something you could see across different transcripts, right? So the result of that case, hold on, sis. I didn't actually make a slide about the results, but the result of the case was that the wife or the ex-wife said that she built the house herself, something that really was the responsibility of the husband. And because she built the house herself, she said that she should get to keep the house and she should get to stay in the house. Now, again, this is a situation where she's living in the village of her husband. And a lot of times if there's a divorce, the woman might go home or, relocate. The husband says that, no, he can't live in the same village as his ex-wife. That's going to cause problems. So the ex-wife said, well, why don't I just take the house away? So it was ruled by the judge that she could take the house apart brick by brick and relocate it elsewhere, so that they did not have the conflict with the in-laws and with the ex-husband that might have ensued if she had to stay in the same situation. So that was seen as something that she kind of earned, right? The husband did not live up to her responsibility, but she had earned this entitlement to stay based on her actions, but because of the conflict that might have ensued, that was seen as untenable. But she certainly had, according to the judge, earned this entitlement, this right now to remove the house, which is something that may not have otherwise happened. It's hard to say, but there's that question. So the idea of there still being these gender expectations that predate the language of rights, right? Those are now being talked about in terms of rights sometimes, and responsibilities and rights are sort of allied with each other. We see that in the case of the withholding of sex, right? The husband had the right to sex, the woman had the responsibility or duty to provide the sex. So rights are being used in a kind of multiplicity of ways, and the language of responsibility or duty is being brought together with the language of rights as well. Yeah, so I talk about this as kind of earning entitlements. You earn the entitlement to resources in certain ways, through working the land, through, especially if you're a wife, through working the land, through bearing children, through the lineage that you're born into. And so these are earned entitlements rather than something that's like an inalienable right in some sense of like the international law. And so that's why I think you see in these transcripts, women making arguments that are along the lines of, how do I create an image of myself as a good wife who has earned different entitlements? Not necessarily like a right in the international law way, even though the language of rights is brought in, but an entitlement that you earn, right? And so you see, for example, people deploying the concept of a persevering wife. Let me see how much time I have. All right, I think I'm running out of time. But there was another case that I wanted to share with you guys. Let me see if I can stop sharing this for a second so that I can access. All right, my technology skills are not on point right now. Let's see. So one of the patterns I've seen in the transcripts is that people will try to find ways to, women will try to find ways to show that they endured. They endured a lot. They did all the things that they were supposed to do. They've earned the entitlement to leave. They earned the entitlement to leave with access to some of the things that they earned. And this was also something that you see in customary arguments, right? But now is talked about in the language of rights. But it doesn't really, in some ways, stray very far from the language of customary rights, customary law. So an example I have is, this is a rather long quote, but I think it's a pretty good example, pretty coherent example of this idea of narrating your earned entitlements. Let's see. So I gave the name of Sabina versus Richard, her husband. We started staying together in the year 1996 while I was pregnant. He started telling me that he was not responsible for my pregnancy. He told me to leave his home. I refused and continued to stay with him. So this could very much be a response to the ways in which you are expected to endure even people telling you to leave. Did you try to do this? Did you try to do that first? But let me continue with the story. In February 1997, I gave birth to our first child, a boy. I had gone all alone to the hospital. I gave birth without a guardian in the hospital. In March 97, he sent some people to take me to my older sister. The people he sent took me there and told my elder sister that he no longer needed me. My sister sent us back and advised those who took me to her to tell my husband that he should take me to where he took me. It's very convoluted in this transcript. When I reached his home, reached back to his home, he started beating me. He was telling me that I should leave his house or else he was going to kill me. I persevered. In June 1997, he ordered me not to do any work at the house. I complained to the village head about what he was doing. The village head talked to him. He told the village head he did not need me there. He ordered me to go home. I went home the same month in 97. I stayed from 97 to 98 without him following me home. He came to my place in April 98, and he was chased by her father, her uncle, but she followed him back to the wife followed him back to the marital home later in the same year. And they stay together very well, right? So, I'm not going to read all this, but essentially there's a lot of back and forth, right? There's a lot of expectations that you're going to keep trying all the things that you have to try to show that you're a dutiful wife, to preserve the marriage, to fulfill what the expectation is of you, what your responsibility and duty is, right? When she complains that she had to go home and he didn't follow her, that was a complaint of the expectation that this is a part of the conflict in marriage, that the wife is not going to stay there if she's being abused always, that she's going to go home, but that's not the end of the marriage. You have to follow. So he didn't perform his duty. So throughout, she's complaining about the ways that the husband didn't fulfill his duty. He didn't come to the hospital. He didn't do this. He didn't do that. So this is a responsibility-based argument, right? And at the same time, she's saying that she was responsible, that she persevered. So throughout, she punctuates this whole, it's much longer than what I just read to you. She punctuates this whole journey and back and forth with this phrase, I persevered, right? And so again, this is very much about making claims based on responsibility, or the earning the entitlement to the things that you have made or created or grown, whether it's crops or access to the land or access to your children. So in some ways, you see this coming together of this human rights language with language that we've seen before being used in customary law about responsibility. All right, where is my PowerPoint slide? All right, I think I'm gonna just put this PowerPoint slide back up real quick and then try to draw some conclusions, because time has passed very, very quickly. Gotcha. All right, so essentially, this is one of the arguments that I'm making and others have made, is that even while people are using the language of rights, they are also using the language that has been used in terms of customary law, where you have to make a claim about being a good wife, and you also have to make a claim about the way that you fulfilled your responsibilities or others have not fulfilled their responsibilities, right? I'm gonna skip that slide. So I guess one of my questions is, what does the language of Nkanza really do if we have so much usage of the language of rights and responsibilities that we see in customary law already? What ideas coalesce around the term of violence or Nkanza, and how might they potentially provide a base from which litigants argue or magistrates rule? So does using the word of Nkanza really bring anything new to the table, or does it simply relabel things that were already considered problematic under customary law? And the other question is, do ideas around violence fall more toward the, when people use Nkanza, does it fall more toward statutory laws or customary law? And I don't want to dichotomize these things, but I question whether or not the language of Nkanza is actually able to overcome this dichotomy that's been created between statutory and customary, and whether or not Nkanza is able to subsume a more rights-based or responsibility-based logic. So I don't know. That's one of the things I want to think about some more. And the other question is, how do interests and asymmetrical, so, you know, whether it's a group self-interest or an individual self-interest, and asymmetrical power dynamics continue to inform the deployment of the term violence as it grounds to argue cases. So I guess here I'm asking, who is more likely to want to use this term violence? Who does this term serve? We see that in some cases that violence can be used to say that a right has been violated, but the violation of rights can be extended to the idea of responsibilities not being fulfilled. And so the use of violence can be taken in very interesting directions, such as when I discuss women withholding sex as being seen as a form of psychological violence, right? So just some more future areas of discussion. The question of whether or not ideas about tradition and statutory law are really being overturned through the insertion of new terminology or new focus in courts. And a question whether or not there's actual displacement or just relabeling of things. Another critique has been that customary law is like a loophole that people use in order to not really uphold equal rights. But I wonder if the insertion of customary law in the statutory courts could, if customary law is transformed or continues to, or becomes more fluid, right, as ideas around customs may change, is there a possibility of customary law actually inserting more fluidity than sort of like the freezing of ideas? Let me see what, I don't necessarily want to talk about all things. And I guess one of my main questions here is the one I have in the bottom of this slide is, how does the framework of violence or cruelty intersect, right? How does this framework of violence as a means to make argumentations and the means to make claims in courts, how does it change the relationship between the ideas of rights, responsibilities, and entitlements, right? How is the complex of those things reconfigured by the insertion of this new terminology? And that's kind of where I want to go with further research and further questions. I think that my time is up for that, and so I will stop sharing my screen and maybe we could move to questions.
Thank you very much, Dr. Wilson, for a very interesting talk. And I think we have already some questions in the Q&A section. So let me go ahead and read Jerry's question. Could you speak to the practices of female genital mutilation and breast ironing through the lens of cruelty, abuse, gender, and rights responsibility?
Say that again?
So could you speak to the practices of female genital mutilation and breast ironing through the lens of cruelty, abuse, gender, and rights responsibility?
All right, breast ironing, cruelty, abuse, and what was the last one? Sorry.
Rights and responsibilities.
Rights and responsibilities.
Mm-hmm.
In terms of female genital mutilation and sort of breast ironing. Some people have also claimed that labial elongation should be included in this. It doesn't necessarily have the same types of impacts as some of these other practices. I think that the way, and if you look at the literature, you'll see this, the way that this has been talked about is that these are the arguments that are used by international actors to sort of define the issue of culture as problematic. So when you think about the international law, there are certain images and there's certain practices that are seen as traditional. This is the way people do it. This is like linked to identity of a certain group. And so instead of seeing the internal workings and the internal types of conflicts and disagreements over these issues that can happen within communities, these practices are seen as by the outside international actors as problematic cultural traditions. So I have to say, like in Malawi, you don't really get the breast ironing and the genital mutilation unless you're talking about the labial elongation, which is something that, I don't know if you guys are as familiar with this, is where I think they start at a young age telling girls to stretch their labia so that, but they don't, when I spoke to women, they weren't even told what this was for. They were just told you have to do this for the future and you'll find out later what this is about. So, which also painful. So in some ways, I haven't even seen this come up in Malawian cases. This is not something that you see come up. So this is, you know, these are not like universal practices or anything like that. And the literature essentially says that these things, again, become similar to what I talked about with the homophobia, right? Is suddenly to do these things is seen as a resistance to Western society, right? So instead of people being able to have arguments around, you know, whether they want to do this or not, it suddenly becomes necessary to say, like, it suddenly becomes a thing where people say, like, well, we hold on to these traditions in part, not only because of this, but, you know, somehow in part to maintain an identity or to make an identity or things like that. I don't know if you guys have read Politics of the Womb that talks about this. So I'm not sure how exactly to put that into the language of abuse, rights, and responsibilities, especially in terms of the fact that it doesn't show up in the court cases that I've been looking at. It's sort of more happening in other communities outside of Malawi. Sorry.
Thank you.
Well, that speaks to the non-universality of you know, cultural practices.
Exactly. And Steve has a question. As concerns homosexuality, has anyone made the legal argument that homophobic legislation has its roots in colonial law, not Malawian tradition, and therefore the culture argument should support dismissing such prosecutions?
That is actually one of the things that's discussed in the book that I mentioned, Politicizing Sex. And I got the book on the floor, so I'm looking at the cover. Politicizing Sex in Contemporary Africa. Part of the argument is that there was not a strong legal apparatus or concern about homosexuality, and it became, you know, and that was something that was, sodomy laws were introduced by colonialism, but sort of the backdating of this came to suggest that no, this was before, and the push to discuss homosexuality as as something that was essentially against the nature of humanity and of Africans in particular, Africans writ large, was something that, again, is a way of using culture as like identity politics type way, post-colonial kind of identity politics. And people have apparently used the issue to say, like, my political opponent is not only does he want to like dismantle our culture, which says that women should do this and men should do this, but he's saying that, you know, he supports homosexuality, which is not an African thing, right? To kind of like smear people with being like westernized and you know, neo-colonial in their mind or something like that. Yeah, so if you check out that book by Ashley Currier, she does discuss this fallacy and the idea that like the things that we consider traditional are not as usually traditional as we think they are, and a lot of times have more recent origin, or else they were a part of some traditions, but there was fluidity in the practice or in things like that previous to especially colonialism. There's other questions though.
Yeah. So this one is from Margaret. In Kenya, for instance, there is concern that many men are suffering gender-based violence in silence. While women usually report violence from their spouses through fear of critical ridicule. Were there cases of men who have reported gender-based violence in your study?
You don't see a lot of that. And I think it might be for the reason that the person who posed the question is saying that there were some things that were seen as kind of laughable, like, or, you know, too shameful, right? So to the extent that women are now able to claim certain things are violence, that maybe they were using the language of just responsibility before, kind of just like, things kind of just like glom together. So that sort of strengthened an argument that they already have, like they're not doing their duty, and by not doing their duty, that's violence, right? So women were able to perhaps strengthen certain standpoints they have, but for a man, like, it was very difficult for them to say that like this woman was doing, it would have to be, I mean, certain things, you know, the way they see violence used against men was some of these ways that I discussed here, was that like a denial of sex, right? So that was something that they were trying to strengthen through the language of violence, but it didn't necessarily make a good, these laws don't necessarily take away the shame of not fulfilling the sort of like gendered expectations of being someone who's not going to be able to be beat upon by their wife or something like that. I think the case had to get really, it had to be really severe before we see that, which is a shame, right? Because the law doesn't say that like men can't be victims of gender-based violence, but the law very much has a language around protecting women and children, right? So I could see how that could be really difficult for men to see themselves in that space, because on one hand you see the law being used to kind of like strengthen these kind of gendered expectations, but it doesn't necessarily have a public face that acknowledges to the same extent that men can also be victims of gender-based violence, because gender is glossed as like, the way gender is used is around women, right? So it's kind of indexes women when people say gender. So I mean, that's an issue. And the only places that I can remember seeing it come up was when a man was saying, I wasn't just hitting her, we were hitting each other, or something like that. I don't know if that's useful, but I love having more of these conversations to think through these things. And also, like, hearing examples from people doing work in different different settings. I would just love to do some like comparative discussions. Yeah.
Thank you. So Leo has a comment. He writes, from my experiences, it seems like Gaza, maybe I'm not pronouncing it well, as used locally captures a mix of arguments, but leaning more towards human rights and duty and rights and responsibilities, but separate from physical violence. Kumenya.
Say that last part.
Is there a difference between, I'm not saying it right, you can see it in the comment, Ngaza or something, Haza.
Yeah.
Yeah, and Kumenya, what, is there a difference there? Because it seems Leo is pointing to a difference in
between the physical and the oh, okay. Leaning more toward human rights and duty and rights and responsibility, but separate from physical violence. I don't know that it's completely separate. I mean, to me, it seems that Nkansa can kind of, like, I gave all of those examples because Nkansa is being used to talk about physical violence. It was used to talk about emotional violence. It was used to talk about financial violence, like you deprived our family, or what was it? What was the big complaint that you see? I didn't include it here, that, you know, we grew our crop together and then you took it to the market because that's men's responsibility, and then you kept all the money and used it on beers or something like that. That was seen as violence, right? All of these things go under violence, and I think physical violence is now seen as like a subset. It's a subset. And so I think the work was not to, the work around that term is to expand the meaning of violence to go beyond Kumenya, right? And to say these other things also constitute violence and cruelty under gender-based violence, because that's how these new laws are essentially redefining violence as not just like beating someone, but all this other stuff is also violence. And in some cases they go together, right? The physical violence is going together with the emotional cruelty or the financial deprivation or those kinds of things. I don't know if that made any sense, but I'm not sure that it's separating. It's not separating those things, but it is quite a strange brew of rights and responsibility, all kind of alike. It seems that rights are being made as not just like you have a right to this, but that this other person has a responsibility to do this, right? So adding in that communitarian responsibility to each other type of language that you expect in you know, certain settings. I don't know if that makes any sense. We got more questions, so let's carry on.
Okay, so Anne has a question. When the judges ruled in favor of a woman, was this implementable? For instance, did the woman get to keep the house?
This is one of the problems of research is based on these transcripts. It's like I can't really do follow-up on all these cases. Right? It's like I go into the archive and I read these cases, and the judges are talking a good game, but the question is, if you go down to the level of where this was more likely to be implemented, is it going to, you know? And I would say they have victim support units now, but the victim support units are small, right? And they are basically put together to deal with gender-based violence issues. But when you talk to them, like, they're basically like doing a lot of intake all the time of people coming in with these cases. So can they go out in the community and enforce all this stuff? And so sometimes to do these things, you basically have to rely on the types of structures that are already in place, like the village head, or sometimes there'll be NGOs. So like in one village I worked in, there was like, I think it was like a German NGO that had created a program for dealing with gender-based violence in villages. And so there would be like volunteer people who were prominent in the community who were trying to implement these things. So by trying to get them involved, but it's a really like hodgepodge of implementers that are involved, you know, and do they really have the power to make that possible? I can't say for sure on any one of these individual cases, but if it's similar to some of the more informal cases, because you're expecting these like non-state actors to do something that you might want the state to do. So they also have these like community police type people who are not really police, who are policing, the kind of like volunteer police sort of, who are trying to implement things. And sometimes that causes issues. I think there was somebody who was, man, I need to go back and look at this story again, but there was like someone who was being punished for beating his wife by the community police, and they like went into his house and they beat him up and they put like plants that cause stinging and itching all over him or something like that. And I was laughing, but you know, that's not, it sounds like, oh, you know, rough justice. But on the other hand, I'm like, wait, what? That's not okay. So it's like this like, you have the law, but you don't always have the infrastructure to really follow up and implement all of these things. And so it's just like, cross your fingers that that the players in place who are kind of doing things on a volunteer basis or village level basis are going to enforce those things. But they may not, because, you know, that's family. Village is usually made up of like people in a family. And so I have to also say that this was like a rural based, most of these things are happening in that rural area. I don't know if I have any examples. I have to go through and look at the, see if it's different when you don't always have those same structures in the city that you have in place in a rural area. Like in terms of like the village head and the family and all of that being in charge of regulating marriage and divorce.
Okay, we have another question from Margaret. Did you find out if the judges were men or women, and how that influenced their judgment?
They were all men. There weren't any women magistrates in the area I was doing research. Now, I don't know if that's changed in the last few years, because like, again, with this set of transcripts I'm using, all of those, and they only goes to 2008, all of the magistrates were men. There's just a couple of them, and they weren't necessarily legally trained, and in terms of like, they're not having any degrees related to law or anything like that. So there were questions about the professionalization of that position, which also need to be further explored. Yeah, I mean, when I talked to the one magistrate who, I feel like it's his fault I started doing this research, because he was saying like, what are we gonna do to stop all these divorces or something like that? And there's too many women coming in here and wanting divorces, and you know, I feel constrained by the law to like give them the divorce that they asked for, but we need to have less divorces. And I'm like, well, it's not my job to stop women from divorcing and running away from marriages that they're finding really troublesome. So it was like, it was interesting to me that someone who is an officer of the court had a lot of internal conflict about the job he was supposed to do, and the people who were trying to take advantage of that structure to bypass. And this is another way that this one particular magistrate talked to me about it. They're like bypassing all these other things that they have to do I mean, you really don't have to do those things if you want to go to court. You don't have to go through your own way. It like adds to your set of evidence that you might have, but the idea that it's required, it can be imposed by a magistrate who is interpreting the rule of customary law under the Constitution. So I can't remember what the original question was.
Or if they were men or women, and if that influenced their judgment. So
I mean, my thought is like, yes, it influenced. I think that's what I was trying to say, that there was certainly this idea of upholding, like women sort of like getting out of control and overusing the courts or something like that. I don't know if a woman magistrate would feel the same way. That's my thoughts.
Very well. I think that was all the questions we have. We have a comment there about violence in a general term, and Kumania as being a more specific type of violence.
I don't know if anybody had any comments or anything to any other comparisons or something like that.
Doesn't seem there is.
Oh.
Yeah,
I wanted to chat with everybody, but like, I guess this is a webinar, so we can't.
Yeah, if people raise their hands, they can talk. We can unmute them, but I don't see anybody raising their hands now. I guess for me, my question is the problems of anything that's about law in Africa is how much familiar are the general population? Like we talk about all these rights, but I wonder how much influence it has if there are any settings that talks about this right for people to know about it. Otherwise, I have the feeling they just go with what they know, which is customary law.
Yeah, and I think that's probably true. And no, I guess for me is that like a lot of this work that is done to inform people about rights comes through NGOs, from my experience, right? The NGOs come in and they have programming and they say, these are your rights. Or sometimes there's, sometimes even I remember people were telling me, this was in Central Malawi, we're waiting for the victim support unit people to come around and give us a lesson about rights and things like that. So it's not that, I think it's not that these ideas don't move, that they don't enter into people's consciousness, because people talk about this on the radio, but I think that sometimes there's like a knee-jerk reaction when they hear like women's rights, right? I talk to men who are like, well, who's gonna protect our rights, right? They're gonna come and take away all our rights and give those rights to the women. Who's gonna stop them from violating our rights? Which reminds me of the question that someone asked about like men being, violence against men. I think you meant specific physical violence, but I'm not sure. Maybe you meant the broader in concept. Right. So I know that these ideas move into people's like vernacular and consciousness, but where I see them really being taken up are in like very specific things. Like I talked to a woman who wanted to go back to school, and she found out she had the right to go back to school, and her husband wasn't supposed to be able to stop her. But she was probably in her 30s, I think. And she knew this was a right because an NGO had come around and had talked about it, and there was like an opportunity provided, right? So when there's opportunities provided for people to do things that sort of promote women's access to certain things that they didn't have before, that's when it becomes really concrete and really where people really have to wrestle with the idea of rights, right? Because then there's like, oh, here's an actual potential. And I remember when I was interviewing that particular woman, she was like whispering because her husband was like, she thought her husband was still standing outside the door, right? So, so there's still like a barrier there. So people becoming aware of certain things like, okay, being denied education is seen as a violation of my rights, because now there's actually opportunity for me to sign up for this thing and to get an education, and I can learn more about business and selling things and growing things and things like that. But how do I assert my right when my husband's standing outside the door and he's like against me going back to school? Things like that. Or NGOs that would come around and say like, oh, we have money for micro loans or something like that. And these are specifically for women, right? In order to increase their access and to push against this economic inequality. It doesn't fix like a whole lot of the apparatuses that position men as having more access to markets and jobs and education and things like that. But it's like, oh, it's a microloan, but only women can have it. So the women I talked to who seized upon this were like, yes, we're doing this to increase, this is our right, things like that. So I wouldn't say that it's completely outside of the awareness of like quote unquote regular people, like people who aren't in the government or who aren't like village heads who are going to seminars and things like that, or NGOs. There is this, and I don't know if it's the same in other countries, but Malawi's got like so many NGOs running around constantly. It's very inundated with the presence of NGOs and the parlance of NGOs. And so there is like some awareness of that. So it's not like an invisible conversation. I don't know if that makes any sense.
Oh yeah, that makes sense. Thank you. And Anne has a reference here for Kenya. If
is there a way to save the chat?
We can send it to you.
Okay, yeah. Definitely
we can send it to you. Mm-hmm. So she posted it on the question and answer section.
Okay.
Suggesting that FIDA Kenya is a good organization to refer to in understanding rights of women in Kenya.
Mm-hmm.
Yeah.
Thank you, guys. I would love to, you know, I know our time is up. I would love to hear more from other people who are doing work on rights and responsibilities and things like that. It wasn't quite as organized as I wanted to be due to I don't sleep anymore during COVID. But I would love to have this conversation essentially like extended if anybody wants to email me or tell me about your work in the same area. Because I think that it's really important to think about these things outside of the isolation of particular communities, because they're not, you know, there's a sharing of ideas and sort of movement between spaces. So.
Well, we are very thankful that you came and shared with us. We learned a lot. Thank you very much. And thank you to everybody who came and asked questions. Hope you enjoyed it. We'll see you next time. Bye, everybody.
Bye, everybody.